So I welcome you all to the session on private international law. We have our chairperson for the session, Sir Dr. Christoph Bernasconi. I welcome Sir and Dr. Bernasconi became the Secretary General of the Hague Conference on Private International Law, and with an extensive legal qualifications, he has led numerous projects focusing on governance and inclusiveness. Prior to joining the Permanent Bureau, he lectured in private international law at the Frisburg University, and he was also he was working as a legal expert at the Swiss Institute of Comparative Law, and served as a scientific collaborator at the Federal Office of Justice in Switzerland. Sir is a board member of the International Institute for Justice and Excellence and the advisory boards of Asian Academy of International Law. Sir, I officially welcome you, and with Sir, we can begin with the session. Please do, sir.
Thank you very much. So I see that the protocol is slightly different here today than it was yesterday, but it was a pleasure to be here. Thank you very much indeed to all the panelists who have joined us here on the stage. Thank you all for coming out on an early Saturday morning to listen to a number of I should say probably a little bit eclectic, but all very important and interesting topics. We are running a little bit late, so I will suggest that I don't present the CVs of the speakers. You are known to the Indian society. Laura Martinez Mora is a colleague of mine working at the Permanent Bureau in The Hague. She is the co-head of the Family Law Division at the office, looking after child abduction, child protection, adoption, and the child support conventions. We also decided to slightly change the order of the speakers, if that is okay. And without further ado, I would like to give the floor to Anil and Ankit Malhotra. They are joining us online. They could not be with us in person, but we are delighted to have their expertise, and there is a lot of expertise in this office, joining us online and talk about the contemporary role of international conventions as sources of private international law from an Indian perspective. And I think Anil Malhotra will be the first speaker, followed by Ankit Malhotra. Anil, if you are online, the floor is yours.
Thank you, Dr. Bernasconi. It is a privilege and a pleasure to be a part of this esteemed panel. And at the outset, I thank ISIL, its team, and most importantly, Dr. Christopher Bernasconi, who has come all the way to take part in this conference. And I remember from olden days, a quarter of a century ago, how we had partnered these events with the late Ram Nivas Mirza, chief founder of ISIL, and Dr. Hans van Loon and William Duncan, who very kindly always associated themselves with ISIL. So on this short note, not taking much time, I am a practitioner for the past 40 years, and I deal with these problems pertaining to marriage, children, citizenship, nationality, divorce, spousal maintenance, alimony, child removal, custody, guardianship, division of matrimonial property, intercountry adoption, succession, inheritance, surrogacy, anti-suit injunctions. We are growing by the day. We are 1.3 billion. 32 million live in over 190 countries abroad. Our overseas citizens of India are itself 32 million, though non-resident Indians may be much, much more. Now, with the passage of time, our marital relationships, our familial bonds, our connection to India has built a plethora of problems. and the magnitude of them is increasing so much that we are finding it difficult to cope up with these solutions. So I am only going to look at the magnitude of the problem and the codified laws we have in existence. Ankit, my co-speaker, will look at the conventional remedies and the best interest of children and how are we adapting. So coming back to where I was, the issue at stake is that our conventional statutory personal family laws are at sea. From an international perspective, let us understand we do not have a uniform civil code. So we have statutory codified laws made by Parliament for Hindus, for Christians, for Muslims, for Parsis. And we do have secular laws for people who want to opt out, but that is optional, it's not mandatory. So because there is no uniform civil code, there is no uniformity within India of statutory norms pertaining to different religious communities. We are a sovereign, socialist, secular, democratic republic. We have a right to life. We have right to personal liberty, Article 14, Article 21. And these rights interpreted by our superior courts in constitutional jurisdiction are equivalent of what Article 8 of the ECHR, Right to Family Life, says. That be so, I am only going to look at two legislations in the codified system of Indian law, which are the only guideline for matters pertaining to one, custody and guardianship, and second, adoption. So insofar the issue of child removal is concerned, which probably is the biggest problem today in India, because we are not a signatory to the 1980 convention, and therefore per se we are at sea with the 96 convention also. I have been participating in events with the Hague for the past 25 years. We got very close to signing the convention, but we are still miles away. I was part of Justice Bindal Committee. We've got a two-volume report, we've got a bill, but we are not. So that apart, the Hindu Minority and Guardianship Act, which is the principal legislation governing custody and guardianship issues in India, does not have a statutory remedy which takes you to court. So if a parent removes the child, he per force has to adopt what we have, a Guardian and Wards Act of 1890. It's not 1980, it's 1890. It's a colonial piece of legislation. It still looks at single custody, and it is outmoded. It is absolutely antique, and it is a complete antithesis of child rights. So shared parenting, joint custody, access of the child to both the parents is far cry. You remove a child, you come to India, you file a petition under the Guardian and Wards Act, get with the Hindu Minority and Guardianship Act, and you sit at home and say, I've got custody. So this is where we get into a difficulty. Now let us come to adoptions. Now we have signed the 93 convention, but then we have a big yawning gap as far as Hindu adoptions are concerned. Now, insofar adoptions under the convention are concerned, they are governed, 93 convention, the adoption convention are concerned, they are governed by the Juvenile Justice, Care and Protection of Children Act 2015. We have taken care of the entire procedure. We have a central authority called CARA, Central Adoption Resource Authority, which takes care of it. But the domestic Hindu adoptions, which take place irreversibly on giving and taking over of a child, and which do not require the approval of the authorities under the JJ Act, have somehow come to be a dilemma, because the adoption regulations have brought in Article 5 and 17, courtesy Article 23. This is something I'm going to ask Laura to address. Article 23 talks of adoption is being certified by an authority of the state to be in accordance with the convention on Article 5 and 17 approval. So if there is a domestic adoption, Kara says follow 5 and 17, but following 5 and 17 is an impossibility because that is the start, not the end. But then the rescue is Article 28 and 37 of the convention, which talks of recognition of domestic adoptions. Now, UK has taken care of this by making an adoption out of 2013, whereby 100 countries, non-conventional adoptions, you can equate them and they can let you. So this is the plethora and the magnitude of what I have to say in the realm of codified law, where I had requested Dr. Christopher Bernasconi to have Laura come in at the end because Laura will give us the panacea. She is going to be the doctor for all our problems. So from that, on that note, I am going to leave Laura for the medication she has to give me, and I'm going to pass on the baton to Ankit, who will delve into the niceties of the issues, that is the remedies, etc., etc. Thank you very much.
Well, I join my fellow panelists and colleagues in thanking ISIL for giving us an opportunity to share our thoughts and perspectives. It is indeed an honor for me to join this panel. Perhaps was the youngest, and an extra honor to speak alongside my father. I want to look at conventional remedies insofar as noting a noticeable trend in terms of finding an alternate solution for removed children in situations where in India, which is signed the 1980 Convention on Abduction, is looking at it as an offshoot for protecting the best interest of the child as understood in the UNCRC. India understands and looks at the principles of comity of courts, determination of best interest of child by jurisdiction of closest contact, but it has found all these under the chapeau of the UNCRC. The courts in India have prioritized the child's welfare and best interest, but have often also considered the factors of the child's habitual residence and the circumstances of removal, the most appropriate jurisdiction also to hear the court. In a matter in 2010, the Supreme Court of India emphasized that while the comity of courts is important, the welfare of the child is perhaps the most paramount consideration which needs to be accounted for. The court also held that the principle of comity must yield to the welfare of the child, which is, as per the court, the matter of utmost importance. But how must one determine the best interest of the child and the closest contact depends on social factors and the habitual residence and the environment and the cultural context, which is often determined on a case-to-case basis. The Indian courts have therefore aligned and looked at the principles of the UNCRC to ensure that the children's rights are protected even in complex international scenarios that align with standards set by international conventions like the aforementioned. The Indian courts and also the Indian advocates have looked at the writ of habeas corpus for seeking an implementation of child rights where the parents are fighting over the custody of the children. Such matters, such as those in Gaur Begum and Neil Ratan Kandu, looked at these matters by referring to English and American laws, and in doing so looked at, and I quote here, the basis for issuance of a habeas corpus in a child custody is not an illegal detention, but the primary purpose is to furnish by a means by which the court, in the exercise of its judicial discretion, may determine what is the best interest of the child, and decisions are reached by a consideration of the equities involved in the welfare of the child, against which the legal rights of no one, including the parents, are allowed to militate. End quote. Now, these decisions underscore a pivotal shift towards a child-centric jurisprudence in the Indian matters regarding custody. They also necessitate a flexibility of application of legal remedies under the writs such as those mentioned above. Moreover, these rulings reflect the judiciary's willingness to adapt to traditional mechanisms to contemporary societal needs. By extending the application of the writ to child custody matters, the court acknowledges the unique vulnerabilities of children and the necessity for the legal system to offer a robust protection for rights of these children. The progressive interpretation facilitates a more humane and a just resolution of custody matters, ensuring that legal processes are responsive to the nuanced realities of familial relationships. But what about the matter of best interest of child? Well, we borrow that from the United Nations Convention on the Rights of Child, which we as India signed on the 11th day of December in 1992. These steps were taken to ensure that this was incorporated in Indian law under Section 29 of the JJ Act, which is the Juvenile Justice Care and Protection Act of 2015, which states that the best interest of the child means the basis for any jurisdiction or decision taking regard to the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical and emotional intelligence and development. This was then further elaborated on in another matter which is known as the Lahiri Sakamuri case, where the court noted that the basis of any decision for taking regard of the child's welfare is to ensure the fulfillment of his basic rights of needs, identity, social well-being, and the factors listed above. The court also shattered the glass ceiling in terms of gender preferences and also the neutrality when it comes to parents, and also further developing on the principle of child welfare and child jurisprudence. In 2017, Justice A.K. Sikri discussed in the matter of parental alienation syndrome. He held that while a child-centric human rights jurisprudence has evolved over a period of time, it is found on the principle of public good that demands proper growth of the child, who are the future of the nation. It is also important to note that the said principle has been quoted and referred to in almost 100 cases thereafter, therefore truly reflecting the vibrant nature of jurisprudence in the Indian system. In the absence, therefore, of a clear codified law on cross-border interparental child removal issues, the much-needed clearer path of judicial precedent will continue to guide the litigants and court, perhaps also similar to what Churchill said in Parliament during the Second World War, as history being the guiding light and lamp in these dark hours. Perhaps that remains true for us as we guide ourselves further and further. But that is not all, and this being the last point that I want to refer to, is the relocation of children, where foreign orders and foreign courts are also debating about a similar issue. Ad hoc mechanisms and agreements, in some sense adopting the roles or cloaks of mirror orders, has become something of a tool of relevance in our practice. It has shown us that in two cases, fought over periods of 3 years each, that this significantly adds to the jurisprudence of cross-border issues and interparental child removal. These issues in Jasmeet Kaur, but also more recently in NK, where a Dutch couple was involved, involves the absence of highlights that in the absence of India's ratification to the 1980 Convention on Child Abduction, the courts must reiterate the balance between the comity of courts and the welfare of the child. As they seesaw between these issues, the resonance of the evolving jurisprudence on cross-border child custody issues must be emphasized with tools such as mirror orders and also international conventions guiding the way, and also creating a pathway for allowing consideration of these international instruments to become much more useful. For an instrument has no utility until and unless someone takes hold of it and utilizes it to its fulfillment, not just for the fulfillment of the parties, but for the larger country and the jurisprudence that it must evolve. Therefore, to conclude, what I would like to share is that this notable trend of finding alternative solutions for a removed child, until and unless India signs the 1980 Convention on Abduction, is an offshoot of protecting the best interests of the child, which is secured under the chapeau, as I started with, under the UNCRC. Aided by the principles of comity of court, determination of the best interest by jurisdiction, and the closest contact for relief is found under the umbrella and jurisprudence of a savvy lawyer, which is what one hopes to become sooner rather than later. With those words, I once again thank the organizers for giving us an opportunity to share our thoughts and perspectives. We are in an unfortunate position to have not been with everyone in New Delhi, but we strongly hope and believe that it will be a fruitful discussion. Thank you very much.